My dear friends, my colleagues in legal profession and my fellow citizens, as we all know well that this 22nd Law Commission has called for objections or views on the Uniform Civil Code, which subject was again reopened by the Law Commission. And in this regard, it is our bounden duty to bring to the notice of the 22nd Law Commission about the implications of formulating Uniform Civil Code. We, on behalf of the Andhra Pradesh SC/ST Lawyers Forum for Social Justice, are submitting a written representation to the 22nd Law Commission and sending the same by email. And I would like to place before you the contents of the letter or representation submitted to 22nd Law Commission. I request all my friends and fellow citizens to take note of the contents of this representation and prepare a similar representation or letter to the 22nd Law Commission reflecting our views as mentioned in this representation, which I am going to read for your kind consideration. To the Honorable Chairman and members of 22nd Law Commission, respected sirs, warm regards from APSCST Lawyers Forum for Social Justice. In response to the notification dated 14/6/2023, we would like to submit the following for your kind consideration and a necessary action on the proposed action to be taken on the Uniform Civil Code. Going by the timing of the notification and the assertions made by the Honorable Prime Minister of India and the ruling party leaders subsequent to issuance of notification, there is strong presumption in the minds of the people that it is at the behest of the government and the ruling party the exercise of calling for views and objections from different sections of the society on Uniform Civil Code is being carried out in spite of the fact that the Honorable 21st Law Commission, after extensive consultations and discussions with wide sections of the society, by spending huge amount of time and money, public money, and published a 185-page consultation paper on reforms of family laws on 31/8/2018 and categorically stated that the Uniform Civil Code is neither necessary nor desirable at this stage. Further, the Honorable 21st Law Commission argued for the reform of family laws of every religion through amendments and codification of certain aspects so as to make them a gender just and equal. In its consultation paper on family reforms, the 21st Law Commission took a stand in favor of equality within the communities between men and women, that is personal law reform, rather than equality between the communities, that is Uniform Civil Code, and further noted that the women must be guaranteed their freedom of faith without any compromise on their right to equality, as it would be unfair to make women to choose between one or the other. With this actual background, one wonders as to how the present exercise is initiated, and the same led to an animated discussion and controversy, diverting the public attention from the main issues facing by the country, and there is heated discussion in the public domain for and against this exercise initiated by the Honorable 22nd Law Commission, ostensibly at the behest of the Union Government. It is not out of place to mention that the Uniform Civil Code is one of the ideological standpoints of the present government. Therefore, they defend this view by taking refuge on the directive principles of the state policy in Article 44 of the Indian Constitution, wherein it is stated that the state shall endeavour to secure for its citizens the Uniform Civil Code throughout the territory of India, and used the name of Baba Saheb Ambedkar the chief architect of the Indian Constitution, saying that he supported the Uniform Civil Code and as such incorporated in the directive principles of the state policy, whereas the opposition parties and the sections who opposed this exercise slammed the move by describing it Modi government's desperation for a justification of its continuing agenda of polarization of the society and diversion from its glaring failures. It is pertinent to note that the Honorable 22nd Law Commission notification does not refer to the consultation paper of the Honorable 21st Law Commission headed by Honorable Supreme Court Judge, and instead of making its recommendations basing on the consultation paper and findings of the 21st Law Commission, which was only a recent one, and without assigning any valid reason for totally ignoring it, instead of having relocating if so necessary, reopening the issue and asking for fresh deliberations over the subject is really perplexing and gives rise for the doubt over the intention of the total exercise. At the outset, I would like to bring to your kind notice that as to what was the idea, intent and message of Baba Sahib Dr. B.R. Ambedkar in advocating Uniform Civil Code and incorporating in Article 44 of the 44, that is Directive Principles of the State Policy. Earlier it was in Article 35 in the draft Constitution, and tried to put it into practice by bringing reforms in Hindu laws to bring the necessary equality of all social groups, women and men, in respect of marriage, property, divorce, etc. The first Law Minister of Independent India and Chairman of the Constitution Drafting Committee, Baba Sahib Ambedkar, supported and advocated Uniform Civil Code, no doubt. But he was very mindful of the apprehensions and objections of minority religious communities. On 23rd November 1948, during the discussions on the Uniform Civil Code in the Constituent Assembly, he said, that is Article 35 of the draft Constitution, now Article 44 of the Directive Principles of the State Policy, does not say that after Uniform Civil Code is framed, the state shall enforce it upon all citizens merely because they are citizens, and sought to reassure the minority members of the Constituent Assembly, saying the future of Parliament may in the beginning make a provision that code shall apply only to those who declare that they are prepared to bound by it. In other words, initially, the application of the code may be purely voluntary. Thus, Dr. B.R. Ambedkar felt that Uniform Civil Code could be introduced as a voluntary code, and that Parliament would certainly not force its citizens to follow it. While asserting that the state has power and jurisdiction to legislate on the proposed personal laws, he also said that all that the state is claiming in this matter is a power to legislate. There is no obligation upon the state to do away with personal laws. It is only giving power. Therefore, no one needs to be apprehensive that if the state has power, the state will immediately proceed to execute or enforce that power in a manner that may be found to be objectionable by the Muslim, Christian, Sikh, Parsi or any other community in India. Therefore, in terms of Uniform Civil Code and freedom of religion, Ambedkar appreciated the feelings of all the members of the Constituent Assembly, especially Muslim leaders, about the Uniform Civil Code. He in turn reminded them that sovereignty is always limited, and in exercise of that power, state must reconcile itself to the sentiments of different communities. In other words, even if the state could legislate on the matters related to personal law, the right to practice and profess one's religion would remain as a fundamental right, and the union government would not use its powers to ride roughshod over the sentiments or apprehensions of minorities. He declared that no government can exercise its power in such a manner as to provoke Muslim community or religious minorities to rise in rebellion. I think it would be a mad government if it did so, but that is a matter which relates to the exercise of the power and not the power itself. That's what Baba Sahib Ambedkar said. Baba Sahib Ambedkar, as a first Law Minister of Independent India, brought a comprehensive Hindu Code Bill to reform the conservative society, Hindu society, as a first step towards a uniform civil code by giving equal rights to women in respect of marriage, property, divorce, etc. But the traditionalists of Hindu Mahasabha and even the Congress leaders, including Constituent Assembly Chairman and First President of Independent India, Babu Rajendra Prasad, opposed the reforms and resulting in the exit of Baba Saheb Ambedkar from the cabinet, as the then Prime Minister Pandit Jawaharlal Nehru could not even utter a word of protest and backtracked to the pressures of the Congress leaders on Hindu Code Bill. Baba Saheb Ambedkar's advocacy and views on the Uniform Civil Code were shaped by his political philosophy, which was emphasized the importance of individual freedom, rationality and equality. He believed that personal laws based on religion and ethnicity were irrational and violated individual freedom, and more particularly perpetuated gender inequality by treating women as inferior to men. He saw Uniform Civil Code as an important tool to achieve a truly secular, democratic and equal society, ensuring social and economic justice. Can the Modi government understand this basic intent object of Baba Saheb Ambedkar in having Uniform Civil Code, and is it really intended to adopt his way of thinking in formulating its policy and bring out a legislation on Uniform Civil Code, or is it trying to bring out a partisan majoritarian Uniform Civil Code to pursue and enforce its ideology on the nation by using its numerical majority in Parliament? In such event, in Ambedkar's reckoning and what he said, it would be a mad government that tramples upon the legislative intent of Article 44 of the Indian Constitution and those who drafted the Constitution of India. It is with this submission of our understanding of the intent of Constitution makers in incorporating Uniform Civil Code in directive principles of the state policy, which is only in the form of an advice and not a binding article on the government, parliament or the nation, as it was met with severe opposition within the Constituent Assembly itself at that time. The wisdom of the Constituent Assembly in not making it mandatory was reflected in its concern of its adverse impact, if enforced, on the diversity of the country. It was very clear. As we know well, that India is known for its unity in diversity, having religious, community, cultural, regional and linguistic diversity, which is not known to any other country. As per the reports, India is a home of 398 languages, out of which 387 are actively spoken. Likewise, the population of India consists of six main ethnic groups, 52 major tribes, 6 major religions, and 6,400 castes and subcastes, and 18 major languages and dialects. Apart from this, every ethnic group, religious sects, even in Hindu religion, there are thousands of castes with diverse cultures and practices, having their own traditions, personal laws in respect of marriage, property, divorce, etc. It is well-known fact that Hindu society itself is divided into thousands of castes and subcastes, and even making some sections as outcasts with discrimination in all aspects of life and practice of untouchability, where the Uniform Civil Code is first required by annihilation of caste system. Likewise, Christians, Sikhs, Parsis, Jains and Muslims minority communities, and most importantly the tribals, have their own personal laws, customs and traditions. In fact, the tribal population of northeastern state and other parts of the country, which are protected under Article 6th schedule of the Constitution by allowing complete autonomy on the matters of family law, having their own procedure under Article 371A to Z of the Indian Constitution. Further, as of now, there are separate laws governing the personal laws of different communities and religions, like Hindu Marriage Act 1955, Hindu Succession Act 1956, the Hindu Adoption and Maintenance Act of 1956, the Garden and Wards Act, the Hindu Widows Remarriage Act, and the Indian Christian Marriage Act, the Indian Divorce Act, the Indian Parsi Marriage Act, the Indian Succession Act, Indian Muslim Women Protection of Rights on Divorce Act 1986, the dissolution of Muslim Marriages Act and other Shariat laws, other personal laws applicable in traditions practiced by Sikhs, Buddhists, Jains and tribal communities, etc. Apart from these personal laws, those who out of their own choice and volition want to be joined in civil union without religious color or flavor can avail the remedies provided by Special Marriages Act 1954. Thus, as it is, there are necessary protections to each sections of the society, religious or otherwise, in respect of family laws. That is why the 21st Law Commission opined that instead of bringing uniform civil code, stressed on the reforms of family laws of every religion through amendments and codification of certain aspects of such laws to make them gender just and equal, and more particularly, women must be guaranteed their freedom of faith without any compromise and their right to equality in all aspects of life. That was the exact intent of the father of Indian Constitution, Baba Saheb Ambedkar, and other constitution makers in advocating the uniform civil code, which should be a voluntary option to the citizens of India. In case if it is framed and brought into existence and not to be implemented by force, which may not implemented by force, which may lead to unnecessary conflict and disturbance in the social order and coexistence of all communities and religions in the society. Further, it is to be noted that such uniform civil code would infringe upon the freedom of religion guaranteed by the Article 25 of the Indian Constitution to all Indian citizens, irrespective of the fact whether they are minorities or of the majority religion. Article 29 of the Indian Constitution protects the right of the minority to preserve and protect their distinct culture, religion. So there is legitimate fear among the minority communities, tribal communities, Sikhs, Parsis, Jains, Buddhists, etc., that the uniform civil code would destroy their unique culture and traditions. If it happens, that would be in utter violation of the basic structure of the Indian Constitution, which contemplates the preservation of the unique character of India, that is unity in diversity. So under the circumstances, instead of initiating fresh debate and dialogue, it would be better to take cue from the views and findings of the Honorable 21st Law Commission and encourage dialogue among different communities to create an understanding for gradual reforms within the communities through social engineering and necessary amendments and codification of certain aspects of present personal laws or family laws of different religions and communities to make them gender just and equal in all aspects of life, to strike balance between individual rights, freedom and communal harmony. So absolutely there is no reason to restart the entire exercise, as there are extremely valid, sound findings and suggestions of 21st Law Commission of India. Therefore, we humbly request the Honorable Chairman and members of 22nd Law Commission to take note of the above submissions into consideration and desist from any action or exercise which creates disturbance among social groups, religious communities and denominations and lead to divisions and polarization in the Indian society, which violates the very basic structure of the Constitution of India as enshrined in the preamble, and we request you to act upon the clear findings given by 21st Law Commission by endorsing its views and findings. Thank you. Thank you very much. Yours faithfully, Y.JayaRaju, Senior Advocate, High Court of AP and also President APSCST LawyersForum for Social Justice, and I hope that the Honorable 22nd Law Commission will take into consideration all these submissions and before finalizing its draft for submission to the recommendations to the Government of India. And at the same time, I request all my friends to go through this text, this text and prepare your own representations or papers and submit the same to the 22nd Law Commission of India on or before 14th of this month, 14th July 2023, so that a comprehensive discussion may take place among different sections of the society without defeating the basic intent of our constitutional objects. Thank you. Jai Bhim, Jai Bharat.